Welcome, everyone, to this second panel discussion of our conference today of Mexican constitutional politics at a breaking point. My name is Jaime Olaiz. I am professor at Universidad Panamericana School of Law in Mexico City and currently a Fulbright visiting fellow here at the Kellogg Institute. I want to thank Aníbal, Denise, Mauricio, and Therese and all the team at the Kellogg Institute for helping in putting together these wonderful panel discussions that we are having today. And this second panel is precisely about something that was anticipated in our first conversation with José Antonio, Alejandro, and Andrés about this democratic erosion in Mexico and its impact in particular in our understanding and practice of constitutionalism, and more saliently in the state of our judiciary and its independence. So for the purpose of this panel, I'm very happy to present our stellar panelists. First, we will hear the presentation of Justice Alfredo Gutiérrez Ortiz Mena, who holds an LLB degree from Universidad Nacional Autónoma de México. Then he has an LLM from Harvard Law School. He presented and was admitted to practice in the U.S. By the New York Bar Association. He had an extensive practice, private practice of law in Mexico in different law firms. And then he joined public service and more saliently as the head of our tax revenue service. And then he was appointed member of the Supreme Court of Mexico in 2012 during the administration of Presidente Peña. Justice Gutiérrez Ortiz Mena has been a champion in the internalization in Mexico of the international system for the protection of human rights in different areas by adjudication. And he will share us during his presentation today the way that brought us at this point in Mexico at this juncture, in which over the last 3 decades, our Supreme Court gained a position and authority that was not present in the original constitutional design in Mexico. So in short, what Justice Gutiérrez Ortiz Mena will share with us is how we came to this point and why at this present juncture, the Supreme Court and the judiciary are so important for Mexico's constitutionalism. So to the audience here in person and in virtual joining today, this afternoon, be very welcome. And I give the floor to Justice Gutiérrez Ortiz Mena. Thank you very much.
Well, thank you very much. First of all, I want to thank the Kellogg School for the invitation, the Universidad Panamericana for making this possible. It is really a pleasure to be here. It's a bit intimidating following Secretary Meath because not only were we law school companions, but he was my boss. So I had better do a good job today. Let me start. And the challenging part is I know a lot of you are not lawyers, and I know a lot of you are not constitutional lawyers. So let me try to translate a lot of what has happened in the court in the last 30 years, because it has been a lot. We started late with real constitutional theory in Mexico. But the last 30 years has just been an explosion of constitutionalism in the country. So let me begin by talking about the evolution of the Constitution, the structural reforms that took place, what they achieved, and then how this court, this new court, started interpreting the Constitution. And it led to some seminal cases in a lot of different areas that touched upon a lot of issues in society that were, I think, very important for the advancement of human rights in Mexico. If you were to study law in the United States, you would point to Marbury versus Madison in 1803 as the seminal case where the United States established that the Constitution was law, and the Constitution is justiciable in courts of law. There is no case in Mexico similar to this. You cannot point to a specific time, you cannot point to a specific case to reach that conclusion. In fact, the evolution in Mexico of the Supreme Court and the idea of a constitution as law, not as a political document, but as law, evolved very slowly in Mexico. Our constitution is from 1917. A little fact, it's the second oldest written constitution in the world, behind the United States Constitution. But throughout most of the 20th century, it was seen as a political document. It was not seen as law. And it was not seen as justiciable in courts of law. What happened? Democracy happened. And I think democracy came and changed the entire backdrop for the Constitution and for a constitutional court. There are two amendments that I will talk upon that I think were fundamental in achieving this framework of a constitutional court. And I would also, two constitutionally Supreme Court doctrines that I think were also fundamental in opening the floodgates. I don't think the court really knew where they were headed when they decided these two cases, but I think looking back, they have been truly opened the floodgates for constitutional justice in Mexico. Today, let me just fast forward to the end of my conversation. Today, the Supreme Court is the arbitrator between powers of government, between the elected branches of government. Today, the Supreme Court holds a significant and very important role in deciding federal and state issues. And today, the court regularly assumes a counter-majoritarian role when deliberating on human rights issues. So from a court that at the end of the 20th century rarely saw the Constitution as justiciable, to a court that assumes a counter-majoritarian role, that deliberates between encroachment issues, between the elected powers of government, or between state and federal issues, is a tremendous leap in 30 years. So let me begin by giving a brief description of our Constitution. Our Constitution at its core was modeled from the U.S. Constitution. It has many of the same institutions. It has many of the same, to put it bluntly, the backbone of our Constitution is very similar to the American Constitution. However, our revolution of 1917 gave it some different aspects. Social rights, for example, which are not present in the U.S. Constitution, were first enacted in the Mexican Constitution before the Russian Revolution even enacted them. So we have agrarian rules in our federal Constitution. We have labor rules in our federal Constitution, and we have rules that govern public education and the education system in our federal Constitution. These were very new in 1917 additions. Also, the state's role in achieving social welfare is in the Constitution. Now, the state's role in achieving social welfare in the Constitution has meant many things during many times. At one point, it meant state ownership. At another point, it meant strict regulation of certain sectors of the economy. At another point, it meant autocracy, where you had the substitution of importation and exportations. Today, it means government regulation within the context of competitive markets and free trade. And I'll get into that a little bit later. Another important thing that's different from the US Constitution in the Mexican Constitution is the democratic model of governance. And I would also say the system of constitutional justice. But let me first address the democratic model of governance. Our democratic system is heavily regulated in the Constitution, and it's subject to many changes. It appears after every election, there's a constitutional amendment to the democratic model of governance. We started out back in 1917 with a majority rule principle, one person, one vote. That is not the case in Mexico. Mexico has a system of proportional representation where we have the majority rule plus a system where, depending on which parties obtain a certain number of votes, they will be assigned a proportional representation in Congress. This is designed to give minorities a larger voice within the context of Congress. So we have a Congress that's made up by majority rule and by proportional representation. Our Congress is bicameral, like the United States. However, the lower house has 500 members, 300 by majority rule and 200 by proportional representation. Our Senate is comprised of 128 members, 3 of which are elected, 2 are elected on the winning ballot, and a third from the ballot that reaches the second place in the elections. So we will have the representation of one of the losing parties in the ballot as a senator. And also we have 32 additional senators that are determined by a list of the political parties depending on the proportional representation. Then we have a National Electoral Institute, which the US does not have. This National Electoral Institute is tasked with counting the votes, with distributing funding, public funding. Elections are almost entirely funded by public expenditures, auditing the expenses. Voter IDs, national voter IDs are issued by this institute. Electoral districts are determined by the Electoral Institute. So gerrymandering, like in the United States, is not an issue. And we have the Institute is also tasked with sanctioning violations of the electoral laws. We have a specialized jurisdiction for elections where we have within the federal judiciary a special branch that only adjudicates electoral issues. And the most important of all, I think, the Supreme Court is the only body jurisdiction where the constitutionality of electoral laws are decided. And this, I'll get back to it in a second, is very, very important. Our system of constitutional justice is also different. The US will review the constitutionality of laws or government actions when adjudicating a case or controversy. This power is not explicit in the Constitution, but it derives from a lot of case law dating since 1803, at least. Mexico's judicial review is explicit and very detailed in the Constitution. Originally, we only had one writ where you could challenge the constitutionality of laws. This was the writ of amparo. It would only adjudicate to the parties involved. It would not have effects ex parte. And it would you could only bring civil liberty issues through the writ of amparo. The structural parts of the Constitution, the division of powers, federalism, electoral issues were non-justiciable in court. Then came one of the most important amendments, the 1994 amendment to the Supreme Court, and it brought with it two writs or two new writs, the writ of la controversia constitucional or constitutional controversy, and the writ of unconstitutionality or acción de inconstitucionalidad. These two writs came at a time when Mexico was starting to take democracy seriously. 3 years later, the lower house of Congress, for the first time in the 20th century, changed hands from the official party to the opposition. And this was very important because institutional differences regarding separation of powers, regarding the encroachment of one power to another, or federal state issues were finally beginning to be adjudicated in courts of law and not in political backrooms. This made the Supreme Court very visible for the first time, and it became an important player in national politics, whether it liked to or not. The controversia constitucional, the writ of constitutional controversy, settles issues between different powers of government. It settles issues between federal and state authorities. Standing is granted to one of the elected powers of government, the executive, the legislature. Standing is also granted to states or municipalities and some autonomous organisms. What this means is that stewardship of our federal state powers and stewardship of our division of powers no longer was in the hands of the president. It was no longer an issue where the president would distribute power. It became an issue for the courts to resolve. It became an issue for the Supreme Court to resolve. Next, the acción de inconstitucionalidad, the writ of unconstitutionality. It's brought by a minority in Congress, 33%. Also, it can be brought by political parties or human rights commissions. And it allows the Supreme Court to decide without case or controversy the constitutionality of a new law. This includes electoral laws, like I said. For the first time, electoral laws became justiciable in a court of law. This again took away the stewardship of our democratic model of governance from the president to the courts. So a lot of this changes, this 1994 reform, was basically removing from backroom deals, from political arrangements to courts of law, our federal model, our division of powers model, and our electoral model. And it removed the discussions from a purely political to a justiciable arena. Then came the 2011 reform. The 2011 reform was very important from a human rights, civil liberties point of view. And let me just touch upon two aspects. First, Article 1 of the Constitution was redrafted, and it created an affirmative duty of all agencies, including the judiciary, all agencies of government, to protect and promote human rights and the civil liberties found within the Constitution. It also established the pro persona principle of interpreting the Constitution. And what this means is human rights, civil liberties must be interpreted with the maximum protection possible. Given two possible interpretations, judges must always choose the one that gives maximum protection. This is to avoid unduly restriction of human rights and civil liberties. So to summarize, the 94 reform to the Constitution granted the Supreme Court stewardship over the democratic model, the federal model, and the division of powers. And the 2011 established for the first time a clear mandate for the Supreme Court, for the federal judiciary, to assume a counter-majoritarian role. What do I mean by counter-majoritarian? The Constitution applies to everyone. And popularity or majority issues do not play a hand when the court is adjudicating a human right or a civil liberty issue. Now, I mentioned two judicial doctrines. One of the judicial doctrines is Radilla, which, as it's known, and it comes from an issue which was adjudicated by the Inter-American Court of Justice. I won't get into the details of the case, but the case basically forced the Supreme Court to expand judicial review. Usually, the way judicial review worked prior to Radilla was if you wanted to challenge the constitutionality of a law, you could only do it through the writ of amparo on a federal court level. That meant that if you were, let's say, in a state court with a civil suit and you found that a law you considered unconstitutional had been applied in the case, you had to wait. You had to wait for the lower court, for the state court to adjudicate. You had to exhaust all the remedies of the lower court. And only once you had exhausted all the remedies of the state court could you challenge in federal court the constitutionality of that law. If you were lucky enough to win and that law was considered unconstitutional, then your case would be retried without applying the unconstitutional law. You could forget any semblance of a speedy trial under this system. After Radilla, we pretty much adopted a system similar to the United States, where local and federal courts, and this is important because it also involves local courts, have the power to refuse to give effect to a law they consider unconstitutional to adjudicate that specific case or controversy. And I think the last judicial doctrine that's worth mentioning that really expanded tremendously the human rights within the Constitution is the incorporation doctrine in Article 1. One of the issues that we were facing in the court was whether the human rights found in treaties had a level on par with the Constitution or whether they were below the Constitution. And the court adopted a doctrine very similar. I don't know how many of you are lawyers, but in the US, when the states during a long time did not have as justiciable the federal rights in the Federal Bill of Rights. So what happened with an amendment after the Civil War, the 14th Amendment of the United States, through the Due Process Clause, the rights of the federal Constitution were incorporated into state constitutions here in the US. The same mechanism was used by the Mexican court. Through incorporation, the Mexican courts incorporated all the human rights that are in treaties to which Mexico is a party. So where there is a human right in a treaty, in an international treaty, where Mexico is a party, that human right will be incorporated into the Mexican federal constitution, and it will become part of the Constitution. That had a tremendous effect in expanding human rights. And this framework, which took 2 decades, I would say, to build up, really opened the floodgates for the Mexican Supreme Court. And it started adjudicating cases after cases after cases in human rights and in division of powers and in federal state issues. The country took democracy seriously. The Supreme Court took the Constitution seriously for the first time. And we can start talking about cases. Let me just go through a couple of what I consider the most seminal cases in the last 30 years. First, Acteal. This was the constitutionalization of criminal procedure. Similar to the Warren Court in 1960s, we had a revolution from above, with respect to criminal procedure. And Acteal was the starting point of this revolution. 1997, in the southern state of Chiapas, there was a massacre within a Tzotzil population, an indigenous community. And there were two governing theories as to what had led to this massacre. First, it was religious infighting within the population of the Tzotziles. Or second, it was a paramilitary group by the government to suppress the Zapatista sympathetic population of the Tzotzils in this part of Chiapas. Obviously, the first narrative won, and it was considered religious infighting, and a lot of the Tzotzil population was charged with murder and several different crimes, and they were arrested and convicted. 10 years later, a law school legal clinic filed an amparo on behalf of the Tzotziles that had been convicted. And they argued procedural irregularities during the trial. The Supreme Court granted cert, and the Supreme Court reviewed the case. And the Supreme Court determined that there had been widespread procedural abuse during the entire trial of the Tzotziles who had been accused. For the first time, the Supreme Court used the exclusionary rule to throw out evidence. And it's very interesting because after this case, we had a human rights in 2011 reform to the Constitution, and we had a 2006 reform to our criminal procedural system. This is before. And this is before Article 20 of our Constitution established a constitutional right to have procedural rules, procedural acts which were in violation of human rights excluded from criminal cases. So the Supreme Court was very forward-looking, and this is the first time one can point to in cases of the Supreme Court in criminal procedure where the legality of police conduct mattered, and where the legality of police conduct mattered as much as the guilt or innocence of the persons being accused. Civil liberties and same-sex marriage. In 2014, a year before Obergefell and Hodges was decided in the US, in Oaxaca, another state in the southern part of Mexico, plaintiffs who affirmed to be homosexual with no intention of getting married filed an amparo writ challenging the constitutionality of Article 149 of the Civil Code. And their argument was that the Civil Code on its face was discriminatory because it defined marriage as a contract between a man and a woman. The federal judge who received the case dismissed the case without prejudice. And the opinion of this judge was that the case lacked standing, that the case lacked sufficient ripeness to adjudicate. They petitioned the court for cert. The court granted cert. And the issue the court faced was, did standing require state action? Were plaintiffs required to attempt to get married? And the reply of the court was no, they did not. The court said that the man-woman construct excluded other types of marital agreements. It sent a stigmatizing message to society. It reinforces negative stereotypes, and it causes structural discrimination. Sufficient for standing, and the court ruled in favor of the plaintiffs and declared Article 149 of the Civil Code of Oaxaca as unconstitutional. Now, the court was careful to differentiate between a stigmatizing message as this one and an ideological opposition to the law. Injury must be objective and unequivocal. Indignant categorization of a suspect class of persons, such as race, sexual orientation, gender, etc., must be present. The court expanded, in this case, standing to further protect minorities from negative stereotypes and structural discrimination. Civil liberties and abortion. In 2007, Mexico City decriminalized abortion. The case, it was challenged in court by the federal prosecutor at that time, and the case reached the court. And the court said, this is a state issue. This is not a federal constitutional issue. It's a state issue, and states are free to decide on the rights of women, on the freedom to choose. After that decision, 20 of the 32 states defined in their constitutions life as starting at the moment of conception. So a lot of the strategy by the litigation at that time was to create justiciable defenses to abortion. The court granted cert in many of the cases, so rape was accepted as a justiciable defense. Health risks were accepted as justiciable defense. Pregnancies of minors were accepted as justiciable defenses. But the court remained with the 2007 original decision that it was a state issue. Finally, in 2021, the Supreme Court reversed this decision. In 2021, the court decided two cases by unanimous decision. The court recognized a woman's personal reproductive autonomy as a federal constitutional right. The legislatures are no longer free to determine when life begins. Central to this decision was a 2011 constitutional amendment to Article 1, the pro persona principle. Now, the same-sex decision and the abortion decision were very, 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 very unpopular. In the 10 years I've been on the bench, the only case we have decided, which has brought people out to protest against the Supreme Court, was the same-sex decision. People were in the streets protesting against the decision. And I think that speaks a lot about the court's role in society as a counter-majoritarian institution. We are not there to be popular. We are not there to win votes. We are there to adjudicate issues that the elected branches of government will not decide upon, precisely because they are not popular, precisely because they are not decisions where people will get elected. And this brings us a little bit further to why we have a big problem. Public policy and judicial restraint. And this will probably be the last case I'll talk about because my time is running out. But 20 years ago, the Supreme Court read into the constitutional vertical and horizontal equity standards for measuring tax issues. And it began to strike down tax laws after tax laws after tax laws after tax laws. It was almost jokingly referred to at that time as the tax court, simply because all the constitutional issues, or the only constitutional issues it would adjudicate, were tax issues. Now, if I were to draw a parallelism with the US, this is the Lochner era of Mexico. This is an era where the Supreme Court would put forward personal preferences to review markets and economic regulation. There is nothing more delegitimizing to a Supreme Court than when it interferes with its personal preferences on economic issues. economic issues are the territory of the elected branches of government and not the Supreme Court. So much like what happened in the 30s with the development of a rational basis test and a strict scrutiny test, the Mexican Supreme Court developed similar tests in order to avoid interfering with public policy. And today the court, except for one or two outliers in cases, has been very deferent to the elected branches of government when they are deciding political policy, public policy, and the court will not intervene with public policy issues. One exception, for example, in 2015, there was an absolute prohibition on the recreational use of marijuana, and the Supreme Court declared the absolute prohibition on the recreational use of marijuana as unconstitutional because it interfered with personal autonomy and privacy issues. And there it applied a strict scrutiny standard. But generally, it will apply a rational basis standard to public policy. Final thoughts. The court has gone from being a rather insignificant institution back 30 years back to a constitutional court, a truly constitutional court. Factors have been constitutional amendments like the 94 and 2011 amendments, court doctrine like the Radilla doctrine, or the incorporation through Article 1 of human rights into the Constitution, and a flourishing democracy. The roles today of the Supreme Court are as arbitrator between the different powers of government, between federal and state, and the democratic model, the division of powers. We have stewardship over these areas on the Constitution. These were areas which had traditionally been the areas in which the President of Mexico would decide the issues. And we have been very, very strong in assuming counter-majoritarian roles where civil liberties are involved. So we have gone from political backrooms to courts of law in 30 years. Now, will this last? I think that's a question better put to the electorate. It's one of the main issues on the ballot this coming election, and I think we will just have to wait and see. Thank you very much.
Thank you very much, Justice, for walking us through the evolution of the Supreme Court to a full-fledged constitutional court as we know it today. I think to downsize what the Justice just explained, it is very interesting how the dynamics of constitutional politics play at the moment in Mexico between what has been called this difficult marriage between constitutionalism and democracy. And in that instance, I have the pleasure to introduce our dear Francisca Pou, who is a senior researcher at the Instituto de Investigaciones Juridicas of UNAM. She's a national researcher in Mexico Level 3. She holds an LLM and a JSD from Yale Law School and an LLB from Pompeu Fabra University. She clerked for Justice José Ramón Cosío for almost 10 years, and she has published extensively on courts, rights, and constitutions. She is widely renowned in Mexico and internationally, and we are delighted to have her today with us. Thank you, Chisca, for joining us.
No, on the contrary, I am very grateful for this invitation. Thanks to UP, to Kellogg, to everyone involved, and especially Jaime. And I think this is a really relevant and timely reflection on Mexico that we can really take the opportunity to try to gather better information and collectively try to evaluate what is happening. Of course, to provide an overview about that, about the situation, the political or the constitutional situation in the country in 20 minutes is a daunting task and can be done in many different ways. So I will start like putting on the table a few like maybe frameworks or ideas that will help me organize the details, and then we'll progressively descend into Mexico and the judiciary, etc. I think that independently of whether we adopt a more legal or philosophical or sociological stance, there are like three main clusters of evaluation that we can take as starting point when trying to assess the performance of a political system. The first cluster, the first pillar, it would be rule of law, peace, rule of law. The second cluster would be democracy. And the third cluster would be social justice, including environmental justice. The first pillar would evaluate how the political system guarantees non-violence, trust, security, non-arbitrariness, integrity, basic autonomy. It has to do with the rule of law, understood as a notion that evaluates how power is exercised or tempered in society in this basic sense. The second pillar, of course, speaks to the sources of political authority and help us distinguish democracy, autocracy, and many things in between. And the third pillar, social and environmental justice, speaks to redistribution, inequality, etc. I think that in Mexico, in Latin America, in all the region, we have been very like we have been very we have acknowledged over the past decades that our democracies have been performing insufficiently in terms of the third pillar, right? I mean, social justice was the great thing that was pending for new democracies in Latin America. Of course, I mean, things were not perfect in terms of rule of law and democracy, but we had this kind of progressive narrative, right? That we had kind of transitioned to democracy and had consolidated at least a bit of electoral democracy at least, and that we were in the way of improving, right? The tough thing was social justice. But suddenly we have seen this change of tendency, right? Because now again, we have deep trouble in terms of the first two pillars, in terms of rule of law and in terms of democracy. And particularly in the second pillar thing in democracy, the evolution in Latin America, of course, overlaps with the situation in so many parts of the world. I mean, this is what we have been studying all this last year, the returns of authoritarianism. We have studied what is different in these authoritarianisms from the authoritarianisms of the past. And, particularly the way, the new autocrats do not throw out the Constitution, but gain elections. And I mean, everybody knows this. I don't have time to go into detail, but the very crucial question for me that, the new autocrats use law to a degree that was not maybe the case, because this is why we speak so much of autocratic legalism and all these new dynamics of using law to undermine limitations. So, this is happening all over the world, and this is happening in Latin America, and this is happening in Mexico. But actually, in Latin America, the situation is so bad elsewhere that, in the varieties of democracy report that we have been looking at so often, Latin America is the second most democratic area of the world, actually, only after Western Europe and North America. Most of the countries in Latin America are still classified as electoral democracies and not as electoral autocracies or closed autocracies. So my hypothesis that I want to use in these remarks to explain what is happening in Mexico and in Latin America in general is that, of course, I am a constitutionalist. I have my own biases. But I think the new political trends are interacting in Latin America with the pros and cons, the gains and the weaknesses of Latin American contemporary constitutionalism. And that this is making a small difference. Maybe, maybe it's not, it will not completely save the situation, but I don't think it's casual that, that some of the processes of neo-autocratization of power concentration have been resisted a little bit, and that, Latin American societies, because of some of the features of the designs of our constitutions, and in particular, I think, and I say this in general, but I want you to read this in Mexico as well. The design novelties in terms of the division of powers, the presence of fourth branch institutions, of independent agencies, the reinforcement of the judiciary, the degree to which we have, built communities of epistemic communities and activism around the law is also playing some role. The opening of the constitutions to international human rights law is also creating the fact the electoral authorities are more independent than in the past. So my sense is that even if I will now go very negative about Mexico and I will select, and I know there's a selection bias, I will pick up on the very worrying things that are happening now, above all in terms of the first and the second pillar, and that in my modest opinion are not compensated in Mexico, but with the gains in terms of social justice. And this is the sad part of the thing. In any case, I think we have to, as Alfredo was saying now, we have to wait and see. No, we have been seeing like U-turns in Brazil, for instance. There's a lot of instability, but at least we cannot assure that tomorrow democracy will be gone in the region. So I want to underline this kind of gymnastics between the political tendencies and Latin America and the designs and tools that we typically find in Latin American constitutionalism. And I think this is also what we see operating in Mexico. Of course, yes, Mexico has a very specific, it has not a completely standard path of constitutional evolution, because it transitioned to democracy without a new constitution. Everything has been so gradual, desperately gradual. But in the end, after 700 amendments, Jaime has been studying this very well. If you see at the Mexican Constitution, we see more or less the same basket of tools that other Latin American contemporary constitutions do have, and I think this can be of help in thinking about trying to be as positive as possible what can happen, with the new administration, even if the situation after these 6 years, and surprisingly, from the perspective of the first two pillars, is much, much worse than what we would have imagined, right? So, but it can be the case also, putting now a pessimist drop, because, it can be the case that the Mexican constitutional system is reaching the limits of its capacity to resist, but okay. So this is the frame, and now I will give a few details about how things have been in the administration of Andrés Manuel López Obrador. To be quick, I will say AMLO presidency, AMLO administration, but in fact, now, as you know, the president is supported at every turn with the majority that he has in Congress. So in the end, we have like a unitary government now in Mexico in this sense. When I say like the AMLO government is AMLO government supported by the legislative, is pretty much a bloc, except to the effect of constitutional amendment, because from the mid-election, they do not have the majorities to amend the Constitution alone. But other than that, it's a kind of block. It's only that I will be saying AMLO because of the extreme personalism of the rule. So it's not bad to say it, but in fact, is this mancuerna between the executive and the legislative. Okay, so as you know, Andrés Manuel López Obrador ran on a leftist platform and was voted massively by millions of Mexicans that, were kind of desperate to leave behind a dissatisfying situation. No, and I think the first panel was very descriptive in this feeling. And, and he got this check of confidence, and, everybody had high expectations. But once in office, he has deployed policies that, with the hindsight of the 6 years, we have to say that in principle are the opposite of progressivism in many. He has followed the authoritarian populist rule book, and he has implemented policies that I don't know if they are more close to a right-wing populism than to left populism. So just to remember, unprecedented militarization in recent Mexico, efforts to control, disappear, or render inoperative independent agencies that in Mexico enjoy constitutional status, efforts to curb the independence and the legitimacy of the judiciary through almost any means, co-optation, direct attacks, both on the institution and on individual members, budgetary cuts, and the ultimate menace of total overhaul of the judiciary that I will describe in the end, the famous proposal, the judiciary bill of February 2024. Defunding of public services and structures, strict fiscal and monetary policy. I mean, first panel, I don't know if it's good or bad, but it was not exactly expected. And yes, he has been like super classic. Environmental regressiveness, as seen, we all know, on the non-green energy policy that he has been promoting, the return of Pemex, the return of fuels, las refinerías, Dos Bocas, and the construction of the Maya train in the last preserved rainforest of Central America. Repressive migration policies, this was also such a surprise, you know? I mean, when I arrived 25 years ago in Mexico, the southern frontier was just open. I mean, there was no, and you know, with the United States, they have had also this, you know, unprecedentedly like repressive migration policy. And of course, daily attacks in his daily morning show to almost all sectors of society, including feminists, academics, science, the press, civil society organizations, all of them portrayed as conservative mafias, and even the entire middle class, no? The aspiracionista kind of narrative that you will remember. His policies do not only seem far from classic liberal politics, but one could say also from left-wing populist as it had been practiced in the past in Latin America in, you know, like Perón or Vargas, or which of course were authoritarian, but were like state-friendly, friends of the big state and inclusive of industrial workers and the popular masses. AMLO has increased the minimum salary, even if we now have this controversy because the basic basket prices have increased as well, and you know, and has improved some of the labor rights, but this has been coupled with impressive efforts to make the state smaller and to make the state ineffective, you know, filled by people that, according to the president, must be loyal, not necessarily competent. And with this almost exclusive reliance on cash transfer, again, first panel, versus a structural redistribution. And I don't have time to go into health and into education, but we all know that this has been what has happened, not progressive like restructuring at all. So I want to give a bit more detail on one dimension that has been crucial in President López Obrador's term in office, the weakening of the check and balances, no? The concentration of power. Again, it's not the only thing that has happened, that this has been happening as well. And this is what I will like underline. I think we can see this struggle, this weakening of the division of powers in three main sides or areas. One, this crusade against independent agencies. Second, the militarization of public life. And third, the onslaught on the judiciary. So let me say something about this, and then I will probably have run out of time. Independent agencies. Independent agencies, which in Mexico enjoy constitutional status, have been portrayed by President AMLO as, you know, idle institutions created by neoliberal presidents to fill in the public administration with friends, incompatible in principle with the policy of Republican austerity that he wanted to be a badge of his administration. So this was from the beginning like very big, right? And he soon disappeared the Education Evaluation Agency and brought the Social Policy Evaluation Unit, the Coneval, outside the protection of the Constitution in a way, or try to make the Transparency Institute inoperative by instructing Congress not to appoint the commissioners, and by massively declaring public information reserved. Again, I am angry because I wanted this guy to be really progressive, and the amount of reserved information we have at this point in Mexico that cannot be, has been just outrageous. And appointed an unconditional pal to the Human Rights Commission, the ombuds, after the previous ombudsman, and this touches on what Alfredo was crucial in challenging before the Supreme Court the militarization status that I will immediately be talking about. So, independently of the fact that maybe there was too many agencies, that some of them were like sobredimensionadas, it's not that the OCAs in Mexico did not deserve a reform. Probably many of them deserved a reform. But on the other side, it must also be said that they represent an interesting diversification of the division of powers, a way of going about the public things with beyond Montesquieu. And, I wrote an article with a colleague that we show how, the Telecommunications Commission did things with regard to indigenous communities that you would not have expected it under the, expertise kind of glasses. I mean, but the problem, and this is something that we see repeatedly in other areas, is that in the end, and as I think illustrated by the fact that the criticisms to the Human Rights Commission ceased the first minute he had co-opted the institution, in the end, the basic agenda behind that was power concentration. It's true. I mean, almost all independent agencies in Mexico have functions that were before under the presidency. So it is actually true that all these agencies were deconcentrating and leaving power outside the presidency. And basically, what he has tried to do is to concentrate, all these powers again under the administration that, of course, the executive controls. One particular agency has received the absolute rage of the president, the electoral agency. Again, I have a lot of details and I won't have time to go into it, but I confío that you know a little bit. The INE is not any other agency, because remember that, Mexico transitioned to democracy not from a military, regime. No, I mean, elections in Mexico were formally held during the 70 years of hegemonic party, only that they were not reliable. So to touch the guardian of reliability, I mean, and we had these discussions before. The INE is so expensive, the electoral system is so expensive in Mexico, probably true. But also, what is the trauma? The trauma of Mexico is non-reliability of election. It's not that we had a military there or no elections. We had elections that they were not reliable. So this was also unexpected because, of course, López Obrador had a very big fight with the INE in the previous election, where he lost by very small percentage, and there was this post-electoral conflict. But, now that he won with this landslide victory, and the elections were, by all accounts, super okay, he still pick up this fight against the agency. And again, I have here the details that you will remember, only that so many things have happened, the budgetary cuts, with the concurrent obligations to organize the recalls, the popular recalls and the consultations, and this was judicialized before the Supreme Court. And the Supreme Court said, INE, don't worry, you have less money, just organize this with the money you have. The INE wanted to be sure that they wouldn't be challenged for administrative responsibility. So this was a big issue. Remember, personal attacks on the president of the INE. Remember the coffin thing. That was terrible. When Salgado Macedonio was denied the registration for the governorship of Guerrero because he had not filed the justification of the pre-campaign expenses, Salgado Macedonio put a coffin with the name of Lorenzo Córdoba and directed all people to go and find a family home of the guys. And López Obrador did not say anything. He said, I mean, the sanction is unfair. So, I mean, I'm just trying to remind you of all what happened in this chapter. But the third dimension, of course, has been the proposals of constitutional of legal reform of the electoral branch in Mexico. Plan A, Plan B, and pending Plan C. Remember, Plan A was a constitutional reform that provided for the popular election of INE and the Tribunal Court and the Electoral Court. And it could not pass because at that point they had lost the constitutional majority. Then Plan B was, okay, let's do something at the level of statutory law that doesn't require, a supermajority, only the majority they have. And the Plan B was this thing of shrinking the logistical capacities of the INE, which was, again, people in civil society thought it was dangerous for the reliability of the system, because you need, it was a logistics that kind of put on the menace the operation of the elections. And Plan B was declared unconstitutional by the Supreme Court, together with other things, because of absolute disregard of the procedure, not for the, for the content. But because there are several statutes that were passed, without following at all the process that was provided for. Plan C, let's change the Supreme Court that declared unconstitutional Plan B. More on this before I close. Second area, militarization. Militarization, this was also completely unexpected because, it was not a topic in the campaign. We were there. It was on the contrary. During the campaign of López Obrador, we already were fed up with the cause of the guerra contra las drogas that Felipe Calderón had launched and all the terrible trouble in terms of that this has caused, the war against drugs and everything. So everybody expected López Obrador, who during the campaign had advocated for hugs and no bullets, abrazos, no balazos, to operate a change of strategy and really go to the causes or whatever. But soon after taking office, in March 2019, with the cooperation of the inoperative opposition parties still at the time, López Obrador eliminated the federal police. There's no federal police anymore in the country on the argument that it was corrupt, and submitted an amendment to Article 21 of the Constitution creating the National Guard. And then Congress approved fast track this constitutional reform and 4 complementary statutes: the law on the National Guard, the law on the National Registry of Detentions, the national law on the use of force, and the general law on the public security system. All of them extraordinarily problematic from the point of view of human rights and control of the arbitrary exercise of power. And a month later, Article 19 of the Constitution was reformed to expand the list of cases where judges are obligated to order ex officio automatic pretrial imprisonment, the famous PPO, Prisión Preventiva Oficiosa, which is incompatible with the American Convention guarantees against arbitrary imprisonment. Why? Because it is automatic and ex officio. You don't have to see at the specific case at all. So it's definitionally arbitrary. Thanks to the mobilization of civil society, in that constitutional reform, the National Guard in the Constitution was put under civilian command. The Constitution still says that. But in the transitory provision of the decree of constitutional amendment, there was this possibility of calling the army to fulfill functions of public security temporarily in a regulated manner. There was this standard that comes from Inter-American human rights law. But then, of course, López Obrador really wanted the National Guard to be fully operated under the military logistics, and finally issued this Decreto Militarista, which in a way activated 3 minutes. Okay, so this remember all these details about this agenda of securitization, militarization, et cetera, and the legal trouble that all this involved. But the second surprising this about this is that in the end, as you know, and this is important for my frame because it is creating such a challenging state of affairs in terms of basic rule of law. In the end, even if the country is completely militarized, it's not that I can condemn this, but as you know, there has not been a frontal confrontation of the cartels. You know, I mean, it is very paradoxical because we have this militarization, but it has not been used to recover territorial control. I don't have time to go into this. I hope that just enunciating the idea will be okay. The country is in terms of asesinatos, forced disappearances, and lack of state control on territory is worse than ever. It's not that I wanted him to repress with the army. You know, I only mark that this is paradoxical. What is the army doing? The army is doing ordinary public administration. This was also a great surprise. Running the ports, running the customs, building the trams of the Maya train, building all the sucursales, I don't know how to say it in English, the Banco del Bienestar, the branches of the bank. So what we have now is an army with an extraordinary amount of economic power, and basically what he said is bypassing the administration that he has weakened and put the army, because the army, you say, you do this road, you do this thing, and the army goes and does it. But with, entering, so this is, and why is this a problem for the rule of law? I don't have to explain. The army has not even a good constitutional regulation in constitutions. You don't see the army because it's supposed to be not there. It's to be completely subordinated to, and you have all this factual space absorbed. Okay, 2 minutes. Judiciary. We are reaching the end. The degree to which this panorama, all these governmental actions has been judicialized in Mexico is unprecedented. This is in dialogue with what Alfredo has been saying. For reasons that have to do with the reinforcement of the Mexican judiciary, the diversification of standing in Mexico, many of the things that I have been enumerating were challenged before the Supreme Court by the independent agencies or by the civil society organizations with new rules of standing, et cetera, et cetera. Moreover, so all this has been pretty much judicialized before the Supreme Court, basically. Second, a lot of judicialization as well, because even if Andrés Manuel has followed the neo-authoritarian rulebook, there's one thing that distinguishes Andrés Manuel López Obrador from Víctor Orbán, for instance, which is the rulebook autocratic legalist. Andrés Manuel López Obrador hates lawyers and law, despises law. He doesn't have the patience to try to undermine the law using the law, all this kind of, let's see how we can do this without creating a, no. He's like proudly anti-legalist in a way. So imagine everything was so irregular that everything was super challengeable before the Supreme Court. So you can imagine the immense pressure this has created on the Supreme Court. All these hot potatoes, all the central agenda of the executive and the legislative judicialized, basically before the Supreme Court. And the Supreme Court, we can leave this for the discussion, has annulled, of course, many of the measures that were against basic constitutional contents. Not everything. Remember the Supreme Court, some things like, remember the consultation, not everything has been declared unconstitutional. Remember that also the ley eléctrica, but of course, many of the things the Supreme Court has declared unconstitutional because they were so evidently so. Despite the enormous pressure it has faced through at least three paths: co-optation, frontal attack, and menace of radical reform. This is the last thing I will say. Co-optation. So I want to say this because Alfredo cannot speak. Cooptation has been central, of course. First, the first avenue has been the negotiations with the former president of the Supreme Court. That caused enormous trouble. Arturo Saldívar was perceived as a president of the Supreme Court that was too close to the government, too far away from the rest of the judiciary. And well, we have this late, then at the beginning of this year, in the morning show, the president said, that when they had trouble with the things, they would go to Saldívar and Saldívar would speak to the judges. I mean, just remember all this. AMLO passed a decree that enlarged the term of the presidency of the Supreme Court for 2 years against, explicit constitutional provision to the contrary. And the Supreme Court declared it unconstitutional. But I mean, we went to that length, right? So this is one thing. The other thing is, these guys are very lucky because AMLO has been able to appoint 5 justices, not 3, which is more or less the provision, in this escalating kind of thing. One was forced to renounce, probably, I don't know the causes, and the other was, from the resignation of, finally Saldívar resigned from the court before the term ended, and so AMLO had another post. So AMLO has appointed 5, not appointed, I mean, presented and the Senate approved. 5. Of these 5 guys, 2 justices have been independent by all accounts. But the other 3 kind of vote in block, always in favor, or almost always in the hot potatoes, in favor of the government. This is why we don't know what will happen, what the new president who will appoint. The majority in the court needs to be 8 to declare unconstitutional legislation. So this is one of the uncertainties that we have open. Attacks, well, I'm going to that, the morning show, all the justices that had the amparos of the public works, Norma Piña, etc. And the third, and this is the last point I know I have to stop, is this reform bill of 2024, which is, very radical from the perspective of, the comparative perspective, and that I think that when Jaime organized this was the constitutional breaking point maybe that he was talking about. But after these last weeks, things have been keeping worse, including menaces of political impeachment of Norma Piña, including, I mean, don't time to go into that, but just a drop about the content of the reform. The reform says that all existing judges must go when the reform enters into force. It's not that they change the retirement age, again, as in Hungary or other. It's not that they get rid progressively of existing judges. All justices must go the day after the extraordinary election of the new judges. And then all federal judges, not only the high court judges as in Bolivia, not only the high courts, all federal judges in Mexico are to be elected by the citizenry, doing political campaign. On the proposal, that is one of the things that I think it's worse, on the proposal of the legislative, the executive, and the Supreme Court. So they will have to deal with the political mafia as always, and they will be an adverse selection effect, terrible, porque who wants to be a judge if you have to go to the political parties and go, no, and moreover, you are elected only for 9 years. And you can be re-elected, but it's not, the judicial career that we have been constructing, et cetera, et cetera, et cetera. We can talk more about that. So this is my final word. Jaime, sorry. The sensation, I think the judiciary bill is, you see something there that occurs not only in this area, but in almost, very sadly, in almost all of the areas we have been seeing. It's not that we had no problems there, and we voted AMLO to try to solve many of these problems. But under any kind of reasonable analysis of what had to be done to solve these problems, this has been the case, like he received the country with a lot of trouble in terms of the 3rd pillar, social justice, but he leaves the country with a lot of trouble now in the 3 pillars, particularly the first one, where the things are so serious. And including in all the things that was like urgent in Mexico. And let me tell you that in the judiciary, there are many like urgent things, because despite all what Alfredo has been telling, the judiciary system is incapable of even processing the most serious human rights violations. But this presidency has not touched fiscalias, the local justice that is pending from 94, the procedures, simplifying the procedures. Nothing of what a reasonable observer would say had to be done has been done. And on the other side, we have all these costs in terms of things that were not expected. So thank you so much. And then this is.
Thank you very much, Chisca. Along with Mexico's constitutional politics, also moderation of this panel was beyond the breaking point. So my apologies. But minding the time, I think, because I'm sure there is an ongoing and very stimulating interest in continuing the conversation with Justice Gutiérrez and with Chisca, I think we should transition to our closing panel that would be moderated by our director, Aníbal Pérez, with the rest of the panelists. So thank you very much for joining us for this second panel, and we will please hold in your seats because we will immediately transition to our closing panel. Thank you very much, and thank you to our two panelists.